Welcome to Brad Explains the Law. Today I'm going to explain why the words in a contract can be so important. But first, I have to tell you that this video is not legal advice, and I'm not your lawyer unless we sign an engagement agreement. There are many specific fact considerations and nuances for each contract, so you should consult your own lawyer on your particular facts and circumstances before making any legal decision. Now, on to the importance of contract language. People sometimes wonder why their lawyers spend so much time working on the exact words in a contract and whether those words are really that important. So I'm going to explain why those words are so important and give a couple of examples of what can happen when the words aren't right. First, not every contract has to be in writing. An oral agreement can be enforceable unless a written contract is required by law. Of course, if the contract is not written and the parties disagree on anything, how will they prove what the terms of the contract are? It will be one party's word against the other, and people's memories tend to change to fit what they want to happen later. In a dispute, the judge's decision may come down to who the judge believes. A classic she said, he said, which can be no better than a coin flip. So when a client tells me that a handshake is good enough because they trust the other party, that completely misses the biggest risk of any agreement based on trust. What if the person they trust is no longer there, or gets dementia, or is incapacitated? If anything happens to that trustworthy person, who will the client have a contract with? The spouse, the kids, a more distant heirs, a receiver, a bankruptcy trustee? Probably going to be someone who has no knowledge of what the trustworthy person promised and no incentive to preserve that relationship you relied on for your handshake deal. So every agreement that will be performed over time should be in writing so that it can be enforced if something happens to one of the parties. And when you put that agreement in writing, why are the words so important? Well, it's because there are rules of law that apply to contracts. The first rule is if the language of a contract is clear, explicit, and unambiguous, no additional evidence can be considered. That means in a dispute, the judge or jury will determine what the contract says and whether a party has breached or defaulted based solely on the words in the contract. They can't consider and won't even listen to the parties testify what they meant or what their intent was or what they think the contract says. The contract language speaks for itself. That's the end of the analysis. On the other hand, if the words are unclear or confusing, or there's a mistake, then the court can't rely solely on the words of the agreement. It must determine the intent of the parties. There are two general factors in determining what the parties intended for the contract. The first one is parole evidence, and the second is rules of contract interpretation that will apply. Either one of those might not result in the outcome you want or expected when you entered that contract. So parole evidence is evidence from outside the words of the contract. If the case is open to parole evidence, then each party can testify what they think the contract means and what they intended when they entered the contract. And in that case, it may come down to which party is most believable. And as we all know, people tend to remember things the way they want to when there's a disagreement later. In addition to parole evidence, the court has rules of contract interpretation that it can apply to decide what the confusing language means. And I'm going to explain a few of those rules. First one is precatory terms are deemed not written into the contract. Precatory means words expressing a wish or desire or intention as opposed to words of obligation like one party shall pay $100 to the other party. Vague language of description or request are not considered if there's an ambiguity in the contract. The court will only consider plain statements of obligation. Second rule, confusing language is interpreted against the party that drafted the contract. If your lawyer wrote the contract and she included confusing language, you might lose on that reason alone. Now we get into what I call the Latin rules. That can't be good because I don't know many native Latin speakers. The first one is called ejusdem generis. That means general words followed by specific words are limited by the specific words. For an example, for a real case, a person conveyed all of their mineral oil and gas rights to another person. Later, there was a dispute over what that meant. The buyer said it meant all minerals, including gold and silver. The seller said it meant only oil and gas related minerals. The court applied ejusdem generis and held that minerals was limited by the more specific oil and gas, and therefore the buyer only got hydrocarbons and not gold and silver. Another Latin rule, inclusio unius est exclusio ulterius. My Latin's not that great, which means inclusion of one is exclusion of the other. This one means that if you list a bunch of things that the contract addresses, then it doesn't address things that aren't listed. That's why lawyers, unfortunately, are fond of writing including without limitation whenever they write a list of things in a contract. There are several of these rules, and I won't bore you with more of them, but you can start to see the problem. In a dispute about unclear contract language or a mistake in a contract, there are rules of interpretation that might be applied to resolve the confusion that have nothing to do with what the parties wanted. And those rules might cause an outcome that at least one of the parties did not want. So enough with the rules. Let me provide a couple of examples where confusion or mistake with two letters caused an outcome at least one of the parties didn't want. I'll provide one simple example and one more dramatic example. The first one involved the word in versus of. So there's a recent case where the contract said the jurisdiction for any disputes would be the courts of North Carolina. One party sued in North Carolina State Court. The defendant wanted to move the case to U.S. Federal District Court in North Carolina, and the court said no. If the contract had said jurisdiction would be the courts in North Carolina, that would include federal court. But the contract said jurisdiction was the courts of North Carolina, and federal court is not a court of North Carolina, even though it's in North Carolina. Only state courts are courts of North Carolina. Now, to a much more dramatic case, a story known as How to Lose a Baseball Team Through Legal Malpractice. This involves the two letters IN, in, and EX, X. In 2004, Frank and Jamie McCourt, who were married, and Jamie McCourt was a lawyer, they bought the Los Angeles Dodgers and planned to move to California. Well, California has some specific and unique divorce property laws, and so it's a good idea for wealthy people to have an agreement about what assets belong to each spouse and what assets are joint assets, and the McCourts wanted to do that. They had lawyers at a prestigious law firm prepare what's called a marital property agreement that was supposed to clearly state what property belonged to Frank, what property belonged to Jamie, and what property was joint property. This is what the agreement said. Exhibit A, Frank's separate property assets. All securities currently listed solely in Frank's name, inclusive of the following: the Los Angeles Dodgers and Chavez Ravine, where the baseball stadium is. First, what was going through the lawyer's mind when he wrote inclusive of? I have some basic drafting rules I use when I'm drafting. One of them is, when possible, if you wouldn't say it, don't write it. Are you going to say, I'll have a cheeseburger inclusive of tomato, lettuce, and French fries? No, you are not. So why would you write that in a very important contract? Fine. Inclusive of sounds like Elizabethan English, but it isn't particularly confusing. But it gets much worse. There were 6 originals of this agreement. 3 of the marital property agreements said inclusive of the Los Angeles Dodgers. But the other 3 agreements said Exhibit A, Frank's separate property assets. All securities currently listed solely in Frank's name, exclusive of the following: Frank's stock in the baseball partnership, including within this exclusion, the Los Angeles Dodgers baseball team and Chavez Ravine. All the lawyer had to do was make two lists, Frank's stuff and Jamie's stuff. Everything else is joint stuff. Absolutely no reason to write inclusive of, exclusive of, or including in this exclusion. Now you have two problems. First, you have bad legal writing that either party can claim is ambiguous, and worse, you have two different signed versions of the same contract that if you can figure out what they say the opposite thing. By the way, there's more to this case. A lawyer changing the exhibits after they were signed without telling the parties, the law firm preemptively suing Frank McCourt, on and on. Suffice it to say that eventually, of course, the McCourts divorced. Frank claimed he owned the Dodgers. Jamie claimed she owned one half of the Dodgers. Jamie won when the court completely threw out the marital property agreement on several grounds, including that it was so poorly written that it did not meet the requirement of a full and knowing waiver of property rights under California law, and because the lawyers had a conflict of interest, because they didn't tell Jamie they were representing Frank, and she should get her own lawyer, and other reasons too. According to Frank, he lost half the Dodgers over two letters, inclusive versus exclusive, and some lawyer shenanigans. And he had to buy Jamie out of her half of the Dodgers. And he sued that law firm for malpractice. Well, actually, they sued him first. Then he sued him for malpractice. I think Jamie might have sued him too, I'm not sure. That law firm no longer exists. So while that is a dramatic example of how a mistake in two letters and some very bad legal writing in general can have a huge financial impact, these stories and cases are not uncommon. In another case, a misplaced comma cost one party almost $1 million. In another case, a date typo cost a New York developer millions in purchase contracts. Examples like this are why good lawyers spend so much time and pay so much detailed attention to the words of your contract. I also have a few contract pet peeves I'll tell you about. The first one is witnesseth. Witnesseth. When I see witnesseth on a contract, I know I'm going to be in for a long day of reading Shakespearean English. Unless you're the town crier at the Renaissance Festival, I'm guessing witnesseth is not part of your vocabulary. I don't want to see it in my contracts. Another example, whereas. When you start saying whereas in your everyday life, I'll put it in my contracts. Actually, no, I won't. But do you go and say, whereas I enjoy beef, I will have a cheeseburger inclusive of lettuce and tomato? No, you don't. I don't want to see it in my contracts. My final pet peeve is the phrase, in the event that. If only there was a shorter word with the exact same meaning, like maybe a two-letter word. If only we could think of a shorter way to say, in the event that. Thanks for watching. Like and subscribe below, and send me an email if you have a topic you would like me to explain.